matters which are no longer active, so that they can then be removed from the roll, and so that when you look at maybe the statistics, you get a more realistic picture of what cases are pending, what cases are, what the backlog is, and everything. I remember, in some jurisdictions, you'd find that some cases have not been prosecuted for 3, 4, 5 years. Sometimes the plaintiff has died, but the case remains on the roll. Sometimes the defendant dies and the matter remains there. Or in some other instances, you find that the person is no longer interested, but the matter remains on the roll and there is no mechanism to weed it out, so that the court's figures and statistics reflect on matters that are actually in progress, which the parties still have an interest in pursuing. And so that when you deal with backlog becomes what is really backlog, and not matters which have just been abandoned by the parties, they've forgotten about them, or the lawyers withdrew, and the matters just remain hanging. And in some instances, the matters have been in court so long that people think it's to pursue them is throwing good money after bad. So inactive cases are referred to, one word that is used is that they are called deadwood. And we will go through the rule as closely as possible. This is what Rule 132 says. It says that if summons in an action for payment of a debt is not served within 6 months of the date of its issue, or having been served, the plaintiff has not, within that time after service, taken further steps in the prosecution of the action, the summon lapses. So which means that Rule 132.1 creates two types of inactive cases. The first one is, and it relates only to an action for payment of a debt. That's the first thing. So if then a summons is issued, but it is not served within 6 months of the date of issue. And when we talk about issue, in fact, there's a very interesting judgment by the Deputy Judge President Angula on the question of issue. I spoke about POCA. POCA, there are two applications. The first one is a preservation order, which is then followed by a forfeiture order. So the point that he was making, what the Prosecutor General used to do would be to issue the preservation order. And then when it comes to the forfeiture, they would not file any affidavit. The matter would be under the same case number, and sometimes they would incorporate what was said in the previous matter by way of reference to say, we rely on the contents of the forfeiture order. And the Deputy Judge President said, no. These are two applications. The onus on the Prosecutor General in relation to those matters is different. The standard of proof at forfeiture stage is different from that at preservation stage. So these are two different applications, and if you read the POCA Act in conjunction with the rules, it must be issued. So he said that those papers which carry the case number of the previous matter, those are just bundles of paper. Because for a case to be issued, it must be given to the registrar. The registrar must give it an identification number, a case number, and everything else. And that is what issue means. So he called these other things bundles of paper. So I'm using the word issue in this context to say when the summons has been issued by the registrar, which means the registrar, in terms of the rules, puts in a stamp and gives the case an identification number, which means it must not be the same with any other case. And normally there's a date stamp which will say when the summons was issued. And it is from that date that you start counting the time from which the 6 months will expire. I hope that is clear. So I was talking about issue. So it's the summons having been issued, or if issued after 6 months, the summons has not been served. Then the summons lapses. Are we clear? Let's move on. Then it says, despite sub-rule 1, if the plaintiff or his or her legal practitioner files an affidavit with the registrar before the expiry of that period. What is that period?
6 months.
6 months. Yes, from either issue or service. Yes. Then, which means this is a process of extending the life of a summons to beyond the period of 6 months. But you have to do that before, because you are extending. You cannot extend something which has already lapsed. So which means that before then you need to move to make an application. This is what it doesn't say make an application, but you have to file an affidavit with the registrar. And there are certain requirements that must be set out in that affidavit. A, that at the request of the defendant, an extension of time in which to pay back the debt claimed or any portion thereof has been granted to the defendant. Which means you say, no, we issued the summons, but the defendant wants to pay, so could we have the life of this summons extend? Let it not expire at the fall of the hammer, so to speak, at 6 months. Or 2, that in terms of the agreement, judgment cannot, except in the case of default, be sought within a period of 6 months of the issue of the summons. That is another thing that you need to say. And then lastly, the period of extension. And then in that case, if you have dealt with these issues, the summons does not lapse until 12 months after the expiry of the period of extension, which means there is still a cutoff period. It does not then, remain active indefinitely, merely because you have made a case for an extension of time. Well, I think it's not. I think the affidavit must be filed, and the registrar must be satisfied that a case as required by this sub-rule has been made. I think it does not extend beyond 12 months. After the period of extension. Which means that does it mean that it then becomes 1.5 years, isn't it? Huh? It would seem so. Because it says that the summons does not lapse until 12 months after the period of extension, which means you do not count from the date of issue, but it is from the date when the registrar grants the extension. So which means that in that instance, the summons will become alive, if I may, and active for a period of 1.5 years. So then what the registrar does upon receipt of the affidavit is to verify compliance with Rule 132, Sub-Rule 2, the one that we have dealt with. And then if satisfied that that affidavit complies, they will then endorse the summons and the court file with a period of extension which is stated in the affidavit, although that is an internal matter, not necessarily one from the perspective of the court. Do you understand what I mean? When I say it's internal, it's what the registrar does, and it does not necessarily, it's not something maybe that the court will know what the registrar does and so. But this is inside information which is given for free. Okay. And then sub rule 3 says, where there is no activity in a case registered with the registrar for 6 months. And maybe here, let me draw a distinction. When we deal with Rule 132, Sub Rule 1, it would appear to me that this is a matter where a summons has been issued and there's probably no notice of intention to defend. And therefore, because in terms of the rules of court, once a case is defended, at that stage the case is then allocated to a managing judge. So which means that when we deal with Sub-Rule 1, we are dealing with matters which have not, at that stage, reached the stage of allocation to a managing judge. It's just a case which has been issued, no activity takes place, or service has been effected, but nothing beyond that has happened for a period of 6 months. Okay. So now it says that where there is no activity in a case registered with the registrar for 6 months, A, after registration of the case with the registrar, and then B, after the filing of any pleading, notice, request, or other document, or C, if the case has been allocated to a managing judge from the time that any activity is to be carried out in terms of Part 3. Oh, I've not finished. That case is considered inactive. Okay. So, which means that there are 3 categories of cases that are considered inactive in terms of Rule 132. And 6 months seems to be the period. If after 6 months a case has been registered with the registrar, and then let's say a notice to defend is filed, and then a further pleading is filed, but nothing happens for 6 months, or if the case has been allocated to a judge, a managing judge, and there's been no activity for 6 months, that case is considered inactive. I think in the last few weeks, we received a number of matters. I think I had over 130 of matters that were inactive. So I'm not too sure about how the system works. But what I'm informed, and this is hearsay, you cannot quote me on this, but you may if you will. But what I'm informed is that the system informs the legal practitioner for the plaintiff before the expiry of the period. I think it's about 2 or 3 times before, to say you need to take action. If you do not, then the matter will become inactive. So once that, whichever of these 3 issues we have spoken about, it will give an indication to the legal practitioner for the plaintiff that the matter is nearing inactive, the stage of inactivity. And then once it reaches that position, then the matters are then allocated to judges if there are matters that had not previously been allocated. Let's say it's a matter where a summons had been issued but had not been served. Or it is a case where the summons had been issued. No. What is the first category? Or which means that, from the date of registration, those categories. And then what then happens is that the system will then indicate that those matters are now due for inactivity, and then they are then allocated to a judge who's going to follow certain procedures that we will deal with. That is a process of getting the matters either moving or kicked out of the system altogether once it is once it's allocated. Yes. No, I think what the rule says is that after the date of filing of any pleading, notice, request, or other document, which means that it may be that a case is allocated to a judge. And some matters fall through the cracks. You will find that maybe a matter is postponed to a certain date. On that date, nothing happens. The lawyers maybe also just forget about the case. They do nothing about it. In fact, one of the things that I discovered when I did the Rule 132 matters this year is that it happens that a summons is issued and the plaintiff cannot find the defendant. And after that, they just leave the matter. The matter is left hanging. And then once the case has reached 6 months, they then decide to issue a new summons. In relation to the same matter, it will have a different case number, but it will be between the same parties. And so this one remains hanging. This is one of the most common things that I found. So this is what may happen. But as I say, it might be that for some reason the plaintiff gets, because the lawyers are also busy. They get busy with cases. If you've got maybe the big corporate clients, which have got a legal secretary who deals with these matters, it's not a personal matter, so they might not be coming to you every day. What is the progress in our matter? You might find that those matters then fall through the cracks. But I think it's exactly what I said. Let's say or maybe let's say the judge's clerk or his office neglects to call the parties for a status, a case planning conference. Those things happen. Because, so many times you find that when you go to motion court, or rather for case management, there are cases that were postponed that the system, for some reason, did not capture. Or there are certain cases which are, or maybe you might find that, because at the end of each day, what is supposed to happen is all the activities that took place in court must then be recorded. If a matter is postponed to a certain date, the order must be entered on that day. And you find that maybe someone neglects in doing so. And then as a result, the matter is not then postponed to any day. And if the legal practitioners do not pick it up, you will find that that matter might just slip through the cracks. And then maybe sometime later, it then falls within the category of cases that are inactive. Matter is settled. That's another possibility. That's another possibility. It happens. It happens. But maybe more with, I do not know, but these things do happen. If you can see, unfortunately, maybe the registrar will be able to draw statistics because I was not the only one. Other judges received more than 100 cases which had become inactive. So it would be very interesting to get a statistic of why the matters became inactive. So all I'm talking about are those that came before me. Others, there was one where it was a matrimonial matter. I think that if the plaintiff lives somewhere else, she doesn't have money to come and continue prosecuting the matter. And that was the reason why there was inactivity. Others, you find that their lawyers withdraw. And after the lawyers have withdrawn, they do not know what to do. You maybe try and find them, you cannot find where they are. And then the matters then eventually reach that period of 6 months, which then brings them within the rubric of the application of Rule 132. So it might be a combination of factors. And one of the things that I'll come to you, Ms. Mokomele, we should not forget is that at the moment, I do not know what the situation in the North is. Mrs. Wakatama can maybe tell us. But here, in the action stream, I am managing between 250 and 300 cases. Those are the cases which are allocated to me. So it is not always easy. You need to work as a team in order to ensure that all the cases or none of the cases actually fall through the cracks. If something has to be done, you need to follow up. Sometimes you'll find that as you work, let's say there's a matter which is postponed to a particular day and something must be done. And one of the problems, I think, is with the lawyers. One thing I've seen and I've told the lawyers is lawyers wait for the court orders before they do anything on e-justice. And I say once an order has been issued, the order has been issued, you have to start complying. You do not have to wait. Once it is pronounced in court, you have to start acting. It does not become operative once you have received the electronic copy. No. So you'll find that lawyers then said, oh, because the only way they know that there's anything to be done is when the machine records that, oh, there's an order, there's a document that has been filed. If that does not happen, they don't follow up their cases. Okay, non-compliance and inactive cases. Okay, I think the connection is that one might lead to the other. What I'm saying is that, in my view, unfortunately, I'm not an expert on this, but the way I look at it is that these things might lead one to the other. Let's say the court issues a case planning conference. So the lawyers are supposed to come and they're supposed to have filed a joint case plan. Let's say for some reason no one turns up. The court postpones the matter for 2 weeks. Parties must show cause why they did not. We're now applying Rule 53. Why they did not turn up. And nobody turns up. Remove the matter from the roll. After that, the parties are not interested. They do not follow the matter. A period of 6 months eventually arrives. Nothing has been done. There's been non-compliance. Court orders have been issued. No one has complied with them. No one has actually appeared in court. So the matter, the court says, rather than keeping on, postponing the matters, rolling postponements, let me remove the matter from the roll. That might actually be something that jerks at least one of the parties to action, and you find that they're in a big lull, a big slumber, and none of them wakes up. If they do not wake up, the matter will eventually come to being inactive because after 6 months, no activity has taken place. Yes, I mean, once there's no activity, yeah, because when you talk about activity, the postponement of a matter necessarily, I do not think, but I think, isn't it, once, if you say the matter is postponed for the filing of A, B, C, and D, if nothing happens, if that is not done, isn't that the non-compliance that nothing has taken place? And therefore, it then leads up to, because I do not know whether inactivity confined to no papers being filed. But as long as the matter is postponed, it is active. Okay, no, the difference is that in terms of Rule 53, the court will say, file your plea on such and such a day. And then you do not file that plea. But that is a matter that is going on. And then you need to be sanctioned for not having complied with a court order. And then, depending on which way the court rules, the matter is going to proceed. If the court sanctions you and say you must pay costs, and then the matter is postponed to a further date for further continuation, that is fine. It never falls within the category of Rule 132. 132, and I think as Mrs. Wakatama eloquently stated, is when the matter comes to a stop and there is no activity that takes place. But maybe the commonality is that the non-activity might result from non-compliance from an order, with an order that had previously been made. Yes, I think that is a critical question. I think we're probably going to deal with the solution later. Because what then happens is that once the case becomes inactive and it comes to the judge then issues a notice, calls upon the parties to come to court and explain why there has been no activity in the matter. Maybe let's go down. Then the answer will come. I think you are on the right track. Where were we? Let's move to sub-rule 4. The registrar must, after consulting the judge president, docket allocate any inactive case that has not yet been docket allocated to a managing judge. So this one presupposes that there are those cases which will be allocated to a managing judge that might become inactive, or that have become inactive, yes. And then there may be those, because a summons has been issued but has not been served, and therefore have not been docket allocated, so it would not be known, they would not have been docket allocated, so that the registrar then confers with the judge president for those matters to then be allocated a judge who's going to move them forward. Is that clear? Okay. Then, a managing judge to whom an inactive case has been referred to in terms of sub-rule 4 must deal with it as if the case had originally been docket allocated to him or her. But I had a very strange incident where there was a case, I think it was a matrimonial case, which had been postponed, I can't remember to what date. And then suddenly, this Rule 132 thing popped up. And then I issued an order in terms of Rule 132 for the parties to come and explain why the matter had become inactive. And they said, Judge, but why? Because this matter was postponed to such and such a day. It is not inactive. I do not know whether there was a crossing of lines there or what. But we then had to ignore the Rule 132 thing and then postpone the matter to, or rather we stuck to the matter, to the date to which the matter was postponed. I do not know how that happened, but it did. No, but there the things that there was an order. There was an order when you opened the documents, the order postponing the matter to that date was there. So I cannot explain why, because when the lawyer said, no, Judge, but the matter was postponed to such and such a date, because what happened to me is that when I saw the Rule 132 notice, I then concluded that the matter had been inactive for more than 6 months, and then I issued the appropriate notice. And then when they drew it to my attention, I actually confirmed that, oh yes, the matter has been postponed to this date, and it is not even a period of 6 months had not elapsed between the two periods. You want to say something, Ms. Mokomele? No, but in this case, there wasn't even a month between the two periods. So I really do not, it was in a future date. Yes. So I really do not understand. But anyway, let's just deal with what we can understand. And which is not technical. Okay. Then the managing judge must give notice on Form 28 to the parties or their legal practitioners as appear in pleadings or other documents filed of record to appear before him or her on a date specified in the notice, and the case must be called on that day to be dealt with in the same way as in a status hearing in terms of Rule 27. So which means that in this case, I think it should apply both to cases which had been docket allocated but which have become inactive, and those which had not yet been docket allocated but in respect of which the registrar has drawn to the attention of the judge president that they've become inactive, and they then become allocated to a judge. So what the judge does is to issue a notice in terms of Form 28, calling upon the parties to appear before him or her on a specified date. So what you need to use are the addresses that are available It might be lawyers, it might be, a self-actor, but that is how the parties are then called. Then where a party or his or her legal practitioner appears on that date, the managing judge must inquire as to why there is no activity on the case. And if the managing judge is satisfied with the reason, he or she must make such order that he or she may consider suitable or appropriate and give appropriate directions for the speedier conduct of the proceedings. So which means that the first level, you don't sanction them, but you give them an opportunity to come and say, why has this matter become inactive? They might come and give reasons. The plaintiff was hospitalized for a period of 6 months. That is the lawyer. I tried to get in touch with the plaintiff. I couldn't, but last week she suddenly came to my office. And then the judge will say, fine, where was the matter? It was at this stage, so now file these and these proceedings or whatever pleadings. The matter is postponed to such and such a day. Then the matter proceeds as normal. Is that clear? That is where the litigant or the representative of the litigant appears in response to the summons that has been issued by the judge to whom the matter had been docket allocated or has been docket allocated to move the matter forward. I think that is straightforward. Then next, if there be no appearance by a party or his or her legal practitioner on the date referred to in sub-rule 7, the managing judge must. So we see here that what the lawgiver says is something that is imperative, which means there is no discretion. If nobody appears, there is only one way that the matter must go. What must the judge allocated to deal with the matter do? A, order that the parties be informed of his or her order referred to in sub-rule 7 at any address provided in terms of Rule 6. In terms of sub-rule 7, the judge called upon the parties to appear for him to inquire as to the reason of the non-activity of the matter. So if there is no one that appears, then the judge must order that the parties be informed that he had issued an order for them to appear. But here it says, to the address provided in terms of Rule 6. What happens in the summons is that for both the defendant and the plaintiff, when they come on record, they give an address, including email addresses, where they can be found. So I think those are the addresses that are used in order to communicate with them. So then the next thing that the judge must do is to postpone the case to a suitable date. By suitable, I think it means more than just being suitable. I think it also has an element of being reasonable about it. I speak about reasonable for the reason that it must be a date that will give the person to whom the notice is sent out an opportunity to prepare themselves and know. You cannot just say it's Saturday today and then you say suitable date. What am I doing on Monday? I know that case fell away. You must come on Monday at 10. No. There must be a reasonable notice for the person to know that he or she is being called upon, because you may find that they live in Katima Mulilo, or they may even, after receiving this notice, say, let me go and find a lawyer. So they go and find a lawyer. So when you speak about a period that is suitable, for me, I would rather use the word reasonable, so that there is enough notice for them, firstly, to know what has happened, to know when they have to go, and to prepare themselves to go and be there. And then C, order that the plaintiff must show good cause on that day why the case must not be struck from the roll. So which means that you issue a notice informing the party that the judge had issued the matter, calling upon them to explain why the matter is not proceeding. And then you identify a date which must be reasonable on which the parties must appear. And then for the plaintiff specifically, it does not talk about the parties. The plaintiff must show good cause on that day why the case must not be struck from the roll. And I think this is because the plaintiff is the dominus litis. He or she is the one who has instituted the proceedings. And if there's any order that is likely to be granted, which is adverse, the plaintiff would probably be the biggest loser. For the defendant, it's a little bit less, even if they filed a counterclaim, because if they're not interested in defending the claim, they may as well have given up on the counterclaim. So the plaintiff is the one who is called upon to show cause why the matter should not be struck from the roll. Yes, I entirely agree. I entirely agree. Because, I mean, the court will then be apprised of the status of the matter. I've had some matters, I'm just trying to think. For instance, a matter almost like that where a settlement agreement was entered into and sometimes made an order of court. And then the person defaults along the way. So I remember that what some of the banks would then come and do is to seek an order. And they now say, because they would maybe have a clause to say, if the defendant defaults in payment, then the plaintiff shall, without further recourse to approach the court. And then there are times when I've insisted on an affidavit and said, no, I do not know what happened. You cannot tell me from the bar what happened. File an affidavit and explain what happened. And then on that basis, I can then be able to issue an order and know that what you are saying is said under oath. And if I have to give an order for an amount which is now in default after some settlement was made of the debt, then I know that this is the amount that is outstanding. So sometimes there are those things that happen. But then, you know, once the parties are there, they'll be able to explain, and in terms of the rule, it will be up to the judge to be satisfied or not satisfied with regard to the explanation given. And if the judge will want certain things to be done, certain affidavits or other papers to be filed to explain, to make the record look complete, then they will say so. In fact, one of the things that I'm very, very particular about is that in court proceedings, let there be a paper trail. Never make an order. If I pass on tomorrow and I've made an order, there must be a basis on the file on which you can understand and yes, why I made the order. Do not always assume that you will be there, because you might be transferred to some other place, and then suddenly there is an order. I remember there's a case that I was doing. It was an exception, I think, which I granted. And because I granted the exception, I then gave the plaintiff leave to amend their particulars of claim by a certain period. And then the parties then decided that, they wanted to apply for leave to appeal. And then they entered a consent order for the matter to be referred to the Supreme Court. And then I asked them, now what about my order? No, Judge, we've agreed. And I said, no. But if the Supreme Court comes and asks me, Judge, why is the matter before us? We see that you made an order that so-and-so must they must amend their papers by such and such a day, and we see that has not been done. So on what basis did you then allow them to come before us without that issue having been settled? So, and then I said, no, I cannot. So this is not part of this. It's just a freebie I'm giving to you for free. But I think it arises from what we were doing to say that, it might be that the judge is not satisfied. Or even you make a verbal explanation and the judge will say, no, please put that on affidavit. And then from that basis, the court can then make an order directing how the matter must proceed going forward. If there be no appearance on that day, am I right at 10? Or the plaintiff fails to satisfy the managing judge in respect of the reason for the non-activity, the managing judge must strike the case from the roll. So once the show cause notice has been issued to the plaintiff, we're not talking about the other parties now, it is to the plaintiff, and the plaintiff does not appear, or if he or she or it does appear on the date nominated by the court, which is called suitable in the rules, and no case has been made, or a case is tried to be made but unsuccessfully so, the judge is not satisfied with the explanation given, then that matter must be struck from the roll, which means the court has no alternative but must have that matter struck from the roll. And then sub-rule 11 says, a case that has been struck from the roll in terms of sub-rule 10 is considered as having lapsed. End of story. You did not come. But if you look at it, this rule is ingrained with some elements of fairness. The court does not come to conclusions without having afforded the party an opportunity to come and explain. Even if they do not turn up, the court still says, come and show cause why. And this is very, very important when it comes to sanctions. One of the, I think it was the Bernard, I can't remember, what is it? Bernardus, I think that was the case. One of the things I said is that when it comes to sanctions, particularly of which are decisive of the direction of the matter, for instance, where you decide that you are going to strike, the defense and grant a claim, I'm of the view that even if there is non-compliance, the party in the court order, you can even say that if the party does not turn up on such and such a day, this is the sanction that might be applied. So that, we don't have a situation where the plaintiff's lawyer says, oh, my lord or my lady, the plaintiff was supposed to file a plea on such and such a date. They haven't done so. So may I ask the court to, in terms of Rule 53(2)(c), dismiss the claim? Because that is the ultimate. I think elements of fairness would have to allow the court to have the defaulting party show cause why this particular sanction should not be granted. So I'm saying that in the applying of sanctions, particularly those that are possibly determinative, or rather terminative, if there's a word like that, of the entire matter, the parties should be given an opportunity. And sometimes they've not even had an opportunity to explain because they just did not do A, B, C, and D. So I'm saying that in applying the sanctions, the court must have a measure of calmness about it, a measure of fairness about it as well, and not to say, oh, because they are not here, claim dismissed. The dismissal of a claim would mostly be in the most grave of situations, but as far as possible, the people must be given an opportunity, and they must know that if they do not comply, the ultimate sanction is going to be imposed. And that marks the end of my comments on these matters? Are there any questions that arise? I almost stuck to the... I think I did, because what I said is that this is a situation where the plaintiff and the defendant enter into a settlement agreement. And then maybe the matter lapses. But what will then happen is that the court will call upon the parties to explain. So when the plaintiff does come before court, he or she or it will have an opportunity to explain that in this matter, this is what happened. And maybe the amount that the court will now be asked to grant, or in order to grant, might be less than what had been previously. Which is why I said that the court might then say, please file an affidavit so that on the basis of the affidavit, I'm going to make an appropriate order. I think that is how I thought I was answering the question. Well, but in that case, you'll recall that this is the second leg. Because earlier, the party will have been asked to come and explain why the matter has been inactive. And then that person does not come. What does the court do? The court then issues a notice. Come and show cause why this matter should not be struck. And the person does not come on that day. What then? Because, I mean, there are people who act in person, and they receive any notifications from the court directly. Because, I mean, any order on e-justice that is issued, it is uploaded. And then all the people who are parties to that matter have notice of the order. Is that not the case? But in the ordinary order of things, if the person is a litigant and it participates, whatever order that the court issues comes to their attention. I'm even informed, I do not know because I'm not on the other side. Lawyers actually say that the email registers gives them notification when something comes in relation to a case. So that should also apply to people who might be acting in person. Well, I would probably say it's a matter of saying, what, do you want to act firstly with the abundance of caution, and also understanding that people, have instituted an action and you cannot just easily, strike it off from the roll. And also, you never know what may have happened. Someone might have been in a coma in a motor vehicle and is in a coma for 6 months or 5 months. And then on the 6th month, the person comes back. That's something, it might be an extreme example, but that might be the reason. He says, my Lord, what case? Oh, that one now, I've been suspended between heaven and earth, or heaven and hell for those months, and now I am back. So, but I think what the rules tries to do, it might look very elaborate, maybe even time-consuming, but I think it is the right that is attached to a person's access to the court, that you cannot just easily cut out a person's right to access the court, and you should give them as many opportunities as possible, because there might be reasons well beyond one's comprehension that might be the basis for a person no longer pursuing a matter that earlier instituted in court. Thank you. Thank you very much. Well, thank you for those very, very kind words. But the mystery about it is that it is in teaching that you learn. So as much as they say that iron sharpens iron, as much as you think I was teaching, but I was also learning. Some of the questions that you asked, I really had to think and dig deep. So I must say that I really, really appreciated the time that I spent with you. If you've learned one or two things and find yourself better off than you were, it is my pleasure and honor. And wherever and whenever you do need to speak or to ask or to refer or to confer, please feel free to do so. I thank you very much for your kind attention. Thank you. And then I'm sure you have all received copies of the Judicial Code of Ethics. Yes. Thank you.